We are back on Amerikwan show. The show is all about bridging cultural gaps between China and America.
We're building a bridge, baby.
And
I'm Danny Vegas. I'm the
welcome,
co-host.
Yeah, my legendary entertaining king of Vegas. Vegas. Donny Vegas.
Okay.
And on my right side is Robert Johnson, representing the law firm R.D. Johnson Law Office. Today we're covering living trust, assets protection, and a little bit of will. So there is a confusion about the differences. As myself and many my friends would think will, living trust, or something pretty much similar. We might go to Office Depot or some document place, purchase this and fill it out, so our family, our loved ones will be covered. Would you please tell everyone what is the difference? Also, how necessary to get help from professional attorney and a law firm like yourself.
Okay. That's probably one of the most common questions is what's the difference between a will and a trust? They're very similar in one way, and what that is, again, both of them enable you to spell out who gets what of your estate when you pass on. But one of the key differences is the will really is a ticket to probate court and having to go through that probate process, which again takes a good deal of time and it costs your estate a good deal of money. Now, and one of the differences too, the will generally is cheaper up front, so you're spending less money up front, but when you pass on, it's going to cost your estate a lot more money. And it's not uncommon for, attorney's fees and costs to, be, 10-15% of the estate, or maybe even more, depending on the estate. So it's a few $100s, difference up front can, be worth a lot on the back end when it comes time to go through that probate process. Now, the living trust, again, its real purpose primarily is to avoid the probate process altogether. And the way that it does that is that you create the trust, which is really this legal entity that exists. Really, it's a contract with yourself. You're contracting with yourself, declaring that this trust is now in existence. It exists because the laws in the state of Nevada says that it does if you follow the required formalities to create the trust. And you create the trust. Again, you have a provision in there, just like with the will, where you spell out who gets what. Generally, you're the trustee of your own trust, so during your lifetime, you're in control. The trustee is kind of like the president of the company.
Okay.
That's the one that has the authority to transact and do everything on behalf of the trust. So as the trustee, you can buy and sell and trade and transfer and invest just like you could as an individual. You're generally the beneficiary of your own trust during your lifetime, or if it's a husband and wife, usually they're co-trustees and co-beneficiaries during their lifetimes. If it's a husband and wife, one spouse passes away, usually the survivor continues to be the trustee of the trust and the beneficiary. And then upon the death of the surviving spouse, then you have what's designated as a successor trustee in the trust who steps into the trusteeship, takes control of the trust, and then the plan of distribution upon death is activated, and the successor trustee is bound to follow the terms of the trust, which spell out who gets what. So they liquidate the assets or make the distribution of the assets in kind if it's specified that way. And that all happens without any court involvement. The successor trustee makes the distributions to the beneficiaries that have been specified, usually the kids. It could go to charity or, however you want it to go. They make the final distribution, close out the trust, and
Call it a day.
All swift, all without, again, any court involvement. So it usually happens much faster with much less expense to the estate than it would going through that statutory probate process. In terms of the importance of having an attorney create the will or create the trust for you, I can't stress that enough. I've seen so many mistakes, and they seem like small things, but for example, with a will, it's very specific. The legal requirements to create a valid will, and for example, in Nevada, you have to, it has to be in writing. Well, we do have an electronic provision. It can't be oral, but or it has to be all in the testator's handwriting and the date and the signature. That's what we call a holographic will. But generally, it has to be in writing, and it has to be witnessed by 2 witnesses. They have to see what we call the testator. They have to see him or her sign the will, and if they're not in their presence, it's not valid. And it's again, if you don't have the 2 witnesses, it's not a valid will.
What's amazing, RD, with all the technology we have, when it comes to this stuff, we're right back into the 1800s. Okay, you got to watch someone sign. You got to have 2 people there.
Yeah.
In some respects, we haven't moved at all when it comes to that, huh?
We haven't. No. Again, we've got a provision for an electronic will, but beyond that, and that's pretty impractical as well. So those rarely are utilized. So we're back where we were in the 1800s, really, in that respect.
So, sorry.
Go ahead.
Oh, I was just going to say, just a recent example with a will. In fact, this was a mistake another attorney had made. Somebody who didn't do estate planning, a personal injury attorney, had the person come in. They did the will, and they had one of the beneficiaries of the will be one of the witnesses. In fact, the Nevada law says if one of the witnesses or one of the beneficiaries witnesses the will, that gift to them is void.
Ouch.
So, and then in this case, they had the testator had given everything to that beneficiary,
Right.
and turns out that gift to him was completely void. So it went to his children that he was completely disconnected with and didn't want
Wow.
anything to do with.
That hurts.
So that completely invalidated his whole intent. So those small little mistakes can be a big thing.
Yeah, so have to set up right in the right way with
Very
someone
important,
who has legal
Yeah.
experiences, like
Yeah. Do you
professional.
have I don't want to. My question is there a point where, we're always talking about estates here and assets. Is there literally a line in the sand, like, well, if you're worth this much, you do it. If you're not worth this much, you know what? It's not really. It doesn't matter one way or another.
Well, certainly the more you have, the more important it is to avoid that probate process, and the more important it is to protect assets when we get to the asset protection side of it. But really, there's no minimum. And again, whether the estate is big or small, there's still those costs of going through probate. So in my mind, it's far better to spend a little bit more up front, do the living trust, and not have that big expense and the time involved by going through probate if you don't do the living trust. So yeah, there's no minimum, and as long as you have some assets that don't pass outside the ordinary course, some things that happen automatically. For example, on a bank account, if you have a joint account holder, the survivor owns the account. You can have a pay on death designation on the bank account. On real estate, for example, if it's husband and wife, or maybe a parent and a son or daughter, if there's a joint tenancy, the joint tenant has a right of survivorship. So when the primary tenant dies, the other one automatically gets it. But if it's husband and wife,
Robert, 1 second.
Sorry,
We only got 30 seconds
going
left, so
to-
it's really important to give out your information.
Yeah, your information,
How do we find you?
how people can hold of you.
one of the easiest ways is to get me on the internet, or email me, but my website is RD as in David Johnson Law LAW.com.
Okay, that's easy.
rdjohnsonlaw.com.
.com. And my email is rob@rdjohnsonlaw.com. So that's easy to remember.
Well, thank you
Yeah.
so much for coming in. That was fascinating.
My pleasure.
All right.
So
Kwan?
good to have you today.
Yeah,
Yeah,
Kwan?
we're like many
Send us
years of
out.
friends. Send it out.
We're done with the segment.
Okay, let's have a commercial break.
Okay, so